Yes, I'm sorry we've kept you waiting a little bit. One housekeeping point. I understand why the authorities bundles have been arranged as they have, and in a way that's very helpful. But speaking for myself, it would also be helpful to have a list of all the authorities with a note of which bundle and tab we find them in. So if between you could do that. I don't much mind whether it's alphabetical or chronological, but just for knowing where to find things, that would be very helpful. Yes?
I was going to turn now to the issues which arise under the Brussels Recast regulation.
Yes.
And the first such issue is the question of whether the judgment claims, or indeed award claims if they fell within the regulation, are matters related to insurance within Article 10 of the regulation. Article 10 of the regulation provides as follows. It simply states that in matters relating to insurance, jurisdiction shall be determined by this section without prejudice to Article 6.5 of Article 7. We can ignore the two sections, Section 3, which are relevant for present purposes. The question of the meaning of that article was considered at length by the English courts in the Atlantic Confidence, which it is a case which is to be found in three places. The first instance judgment of Mr. Justice Tier is at bundle B1, tab 13. The Court of Appeal decision is at bundle B1, tab 15. And the Supreme Court decision is at bundle A5, tab 51. But for present purposes...
That illustrates the utility of the request I just made.
It does. For present purposes, my lords, I wasn't going to take your lordship to any of the relevant those authorities, because the relevant sections of the authorities are all set out in the decision of Mr. Justice Butcher below, paragraphs 119 to 121 of his judgment. Which is, as your lordship knows, lordships know, at tab 7 of core bundle 1.
Yes.
They're fairly lengthy excerpts from the three levels of the decision. I don't know whether your lordships have had the opportunity to read this recently, but I was assuming probably you would have done, and therefore I wasn't going to take your lordship through the...
Well, no, don't simply read it out, but highlight what you want to.
Well, what I was going to do is simply to seek to summarise precisely what the proposition was, or the principle was, which the various courts held, and what the courts held is that the question was whether or not the insurance aspect was simply part of the background, or in the phraseology adopted by Mr. Justice Tier, part of the pathology of the action, or whether actually the insurance aspect was more closely connected than that. So, if at paragraph 69 of the decision of Mr. Justice Tier, this point is set out most clearly, so perhaps if I can ask the lordships just to read paragraphs 69 and 70, which are set out in paragraph 119 of the decision of Mr. Justice Butcher. then going over the page to paragraphs 77 and 78, that's the sections in the Court of Appeal decision dealing with the matter. And as your lordships will see, the Court of Appeal effectively agreed with Mr. Justice Tier that in the Atlantic competence, the position was indeed that this was an insurance question, essentially because although the settlement agreement was interposed between the insurance contract and the claim that was made, the claim that was made was to void or rescind the settlement agreement and restore the rights that existed under the insurance contract. And then at paragraph 121, Mr. Justice Butcher's judgment, if one goes to subparagraph 40, which is the section of the Supreme Court decision in the Atlantic Confidence, most relevant here, from the speech of Lord Hodge, then the submission that had been made in the Supreme Court was by reference to a case called Brogsitter, and there actually the Supreme Court held that the Brogsitter test was indeed met on the facts of the Atlantic Confidence, because, as was here stated, the insurer's claim is that there has been an insurance fraud by the owners and the managers for which the bank is vicariously liable. Such a fraud would inevitably entail a breach of the insurance contract, as the obligation of utmost good faith applies not only in the making of the contract, but in the course of its performance. And there's reference there to the pursuant dredging case. It's therefore not necessary for this court to analyse the proper application of the jurisprudence in Brogsitter. So again, the Supreme Court took the view that on the facts of the Atlantic Confidence, then the insurance claim was indeed an insurance claim, because it was a claim to set aside the settlement agreement and then to sue on the insurance contract, which by virtue of the setting aside the settlement agreement would govern the relationship between the parties. So that's where the nature of the relationship between insurance and the cause of action relied upon by the claimant party. It's not enough that insurance is in the background, it has actually to be in the foreground of the claim. And in that regard, can I also refer your lordships briefly to the Cabot case, which is in bundle B2 at 28. Decision of the European Court. This is a case that we will be coming back to in relation to the question of weaker parties.
Yes.
But for present purposes, then the relevance of the case lies in what the Attorney General said in his, the Advocate General said in his discussion of what an insurance matter is. That discussion starts at paragraph 29 of his judgment. Paragraph 30, he makes the point that the regulation doesn't define the notion of insurance. 31, he makes the point that matters relating to insurance must be interpreted autonomously and uniformly. that apart from that general observation, there appears to be no EU-specific definition of a matter relating to insurance. But the case law of the course has provided two types of casuistic guidance, by inclusion and by exclusion. Within the first category, the court observed by reference to the similarly worded Brussels Convention that the insurance-related jurisdictional rules apply to certain types of insurance. On the side of exclusion, Article 1.2c clearly eliminates social security matters, and 35 reinsurance is excluded.
Yes, that's mainly concerned, isn't it, with what amounts to insurance. The case being concerned with whether payments by an employer under a sick leave scheme.
It is, well, yes.
It's not so much concerned with the nature of the relationship with insurance which a claim must have in order to be a matter relating to it.
Well, it's the next paragraph I was going to refer your lordship to, which has to do with that.
Yeah.
Paragraph 36. See, he says, I do not think that it would be either necessary or wise to attempt to provide a general and exhaustive definition of what is a matter relating to insurance, and hence what is insurance. That can be left in the hands of legal scholarship. There is, however, one element that emerges from the reviewed case law, naturally tied to the logic of the Brussels Convention regulation system. For the purpose of international jurisdiction, the basis for ascertaining what is a matter relating to insurance is essentially, quote, title-based, unquote. Is the title for which an action is launched against a specific defendant, in other words, the cause of that action, the ascertaining of rights and duties arising out of the insurance regulation? If yes, then the case can be deemed as a matter relating to insurance. So one looks at the nature of the cause of action asserted by the claimant and asks whether that cause of action is an insurance claim. If it is, it will come within the insurance section. If it is not, it will not come within the insurance section. Your Lordship is quite right that the actual decision had to do with the point that your Lordship has identified, but this particular paragraph does actually shed light on how you identify whether something is an insurance matter for the purposes of Section 3 or not. And the answer the Advocate General gives is that you look at the nature of the cause of action asserted by the claimant. If it's an insurance claim, it comes within the section. If it is not an insurance claim, it doesn't.
Was the Advocate General's view adopted by the court in general? In general, his view in this case seems to have been that the previous authorities were in need of clarification, which might be code for a bit confused, and the court doesn't seem to have gone down the path which he recommended.
No, and it's certainly right to say that this particular paragraph was not actually specifically adopted by the court.
Right. Okay.
But I would submit that it is a correct analysis and is in line with the analysis that the Supreme Court in the Atlantic Conference set out. That's to say, one looks at the nature of the claim in order to determine whether in fact it is an insurance matter, so as to fall within Section 3 and so as to attract the relevant protections that Section 3 brings into play. Then, if one asks, by reference to that test, whether the club's claim in this action is an insurance claim, the answer I would submit is clearly no. The club's claim is based upon the arbitration agreement, not the insurance contract. The fact that the arbitration agreement, which is of course a separable agreement from the agreement of which it forms part, happens to have been included within an insurance contract, does not mean that the club's claim or breach of that arbitration agreement is an insurance matter. It is an arbitration matter. It is a claim for breach of that separable arbitration agreement.
But do we not need to look at both at what is the nature of the right that's said to be breached and what constitutes the breach? And the breach, in this case, is said to be the pursuit of an insurance claim, to put it.
Yes.
And that's, as I understand, is what's said to be the connecting factor. So that one doesn't stop the analysis if we adopt what the Attorney General says and look at cause of action, simply at where the right or obligation is derived from.
Well, my Lord, the breach is in the pursuit of what is an insurance claim, I accept, but the breach is in the pursuit of that claim in the wrong forum. And it's the fact that the claim is pursued in the wrong forum which is the gravamen of the charge. Exactly the same position would appertain if the arbitration agreement was in a charter party or a sale of goods contract or any other form of contract. The fact that the background, and I emphasise the word background or pathology of the dispute is an insurance claim means that there is an insurance claim out there, but the nature of the cause of action that is sued upon is the breach of the arbitration obligation. The fact that that arbitration obligation arises by virtue of the making of an insurance claim is, I would submit, nothing to the point for the purposes of determining whether Section 3 applies. And again, taking a step back, one asks, well, why is Section 3 there? The answer is actually to provide protection to those people who are making claims on insurance agreements, because they are then entitled to make those claims, and it's those insurance claims that they're then entitled to make in the courts of their own states, where the regulation applies to those claims.
Would you accept that the state's proceedings in Spain are matters relating to insurance?
Yes.
And the club's proceedings in England are intended to deprive them of the benefit of being able to sue in Spain and obtain judgments there, because they will undo the remedy which the states achieve in those Spanish proceedings.
No, I would respectfully say that the club's proceedings are intended to ensure that that Spain's claims are brought in the correct forum, viz. London arbitration. The claims that Spain is bringing...
No, your claims on the judgment, which is what we're talking about,
Yes.
are premised upon judgments being obtained in Spain, which the states are able to enforce, and you then get damages or indemnity back again to cancel their ability to get the money from the club.
Well, taking it in stages, our claims on the judgments are for the failure of Spain to pursue their claims in the correct forum. The loss that flows from that breach is twofold. The first is costs. Costs actually incurred in defending proceedings in Spain, that being the wrong forum for the defence of those proceedings. The second would be, if and to the extent that the judgments are in fact enforced, the liabilities that the club would be under as a result of that enforcement. But that flows from that latter loss, if it is suffered, which depends on whether or not the judgments are enforceable.
Yeah, and that's an argument for another day. I understand.
Argument for another day. But again, it comes back to the point my learned friend Mr. Young made, that in a sense, as he would put it, conundrum that by exercising your right to obtain a judgment, you are therefore in breach of an obligation. And I say the answer to that is that the breach of the obligation was in obtaining the judgment in the first place, in circumstances in which you should have brought your claim in So, in a sense, if you ask, well, what is the starting point? The starting point is that you should never have got the judgment, and therefore you should never have been in a position to enforce it, and you only got the judgment because you brought your action in the wrong forum. So, I would submit that the way that your Lordship puts the point to me is perhaps rather loaded, and that again, going back to the purpose of the club's claims, what the club's claims were intended to do was to enforce the obligation of the states to arbitrate their claims, and it is because of the breach of those obligations that the club makes its various claims, including the judgment claims.
Well, that was the purpose of its seeking the declaratory relief, which has ended up in the judgment. But the purpose of the judgment claims with which we're now concerned is to get the benefit of the consequences of not complying with the declaratory award. So that it is, as my Lord says, at least in part, to undo the obtaining of a judgment on an insurance claim.
Yes, I would accept that. What I would submit, though, is that in a sense there's two aspects to this. One is that, but if one asks, well, what is the cause of action that is sued upon? The cause of action is the failure to adhere to the promise to have the relevant claim determined in London arbitration. If one asks, well, what is the consequence of getting that promise enforced? One consequence of getting that promise enforced may be that the state is deprived of the fruits of its breach of that promise, viz. The judgment in Spain that it has obtained in insurance related proceedings. But the fact that the breach by Spain consists in the obtaining of a judgment in insurance proceedings doesn't mean that the club's claim against Spain, based on the failure of Spain to adhere to its obligations to arbitrate in London, is itself an insurance matter.
Do you accept the judge's distillation of what the Atlantic Confidence decided at paragraph 122 of the judgment, so that your complaint is that in making the evaluation as a matter of substance and reality and applying common sense, he came to the wrong conclusion, or is there something wrong, and if so, what, with his distillation of principles?
So, can I just find the judgment again?
Yes, of course.
I think the answer to your Lordship's question is that, subject to the CABIC point that I've just made, obviously the judge did not comment on CABIC, he didn't take that paragraph of CABIC into account. Subject to that point, we would accept his distillation of the proceedings of the principles set out in the Atlantic Confidence. We would then say, however, that he failed properly to apply those principles because he failed properly to appreciate that the nature of the complaint was not an insurance complaint, but was at root an arbitration complaint based upon the failure to adhere to the appropriate forum selection clause, i.e. the arbitration clause.
Yes, right.
And one example of that is, I would submit, in paragraph 123 of his judgment, where he sought to rely upon the Atlantic Confidence in support of his conclusions. But in my respectful submission, the analogy that he sought to draw with the Atlantic Confidence is a false analogy. So he indicated that the fact that the claims were to seek redress for failure to abide by the judgments didn't mean that they weren't matters relating to insurance, said any more than the intervention of the settlement agreements did in the Atlantic Confidence. My point is, as I've already indicated, that in the Atlantic Confidence, then the nature of the action was to set aside the interposing factor and therefore to restore the status quo ante, namely the rights of the parties under the insurance agreements. And so what the underwriters were therefore seeking to do was to enforce rights under the original insurance agreements, having obtained the rescission of the settlement agreements, which would otherwise have stood in the way of their enforcement of their rights under the insurance agreements. By definition, that was an action on the insurance. Conversely here, then the interposition of the judgments was an interposition of something which was included the indication that the states were obliged to pursue their claims in a particular forum, and it's for breach of that obligation that the club sues. That is the cause of action that the club sues upon, even though insurance, I quite accept, my Lord Justice Popplewell put in the background, the claims that had to be arbitrated were themselves insurance claims. I would submit that, taking a step back, then the position is really a consequence of the separable nature of an arbitration agreement. The fact of the matter is that it is that separate agreement that we are suing in relation to. The fact that that separate agreement has originated within an insurance contract doesn't actually have any bearing on the nature of the cause of action that we rely on. We would also submit that the judge's approach to this issue was inconsistent with his approach to the arbitration section, because if the judgment was one step removed from the obligation to arbitrate, which is what the judge held in relation to the arbitration exception, it was further still removed from the insurance obligation or the insurance claims. The judgment had nothing to do with the claims of the club or the insurance, other than in stating that those claims had to be arbitrated. And lastly, then, the judge, in relation to this issue, focused not on the nature of the claim, as he had done in his consideration of the arbitration exception, but on the purpose of the proceedings. And he held that those were to enforce obligations which arose from an insurance policy. But this is really the same point that I've already made. The approach is ill-founded because the question is whether or not the action is to enforce insurance obligations, to which the answer is no, it is not. Instead, it is an action to enforce the obligation to arbitrate, albeit the obligation is to arbitrate insurance claims. And that's that topic, unless I can give any further assistance on that.
No, thank you.
I was then going to turn to the question of whether the states are entitled to rely on section 3 if section 3 is applicable. And that turns upon the question, various questions as to whether or not the states are within the category of weaker parties. As your lordships will probably be aware, then the Atlantic Confidence, going back to that case in the Supreme Court, that is at A5 tab 51, considered the question of how one went about determining a party was a weaker party for the purposes of the regulation. They considered that question at some length. These are paragraphs 32 to 60 of the judgment of the Supreme Court. In the Court of Appeal and in front of Mr. Justice Tier, then the courts had held that the bank, your lordships will remember the facts of this case, this was the case where the ship was scuttled. The insurers then sought to avoid the settlement agreement, and the bank was the loss payee under the insurance and was therefore a beneficiary under the insurance. In relation to conditional benefit, Mr. Young showed you the sections of the case that dealt with conditional benefit, and your lordships saw that there the critical factor was that the bank had never made a claim on the contract, and therefore they did not come under the obligation to litigate in this jurisdiction, which would have arisen had they made such a claim. The Court of Appeal and Mr. Justice Tier held that the bank was not entitled to the benefit of Section 3 because the bank was not a weaker party within the meaning of the authorities. And your lordships can see that if we go in paragraph 32, between letters B and C, Lord Hodge states that in spite of this success, the bank did not obtain the protection of Article 14 of the regulation, because although their reasoning diverged, both Tier J and the Court of Appeal held that protection was available only to the weaker party in circumstances of economic imbalance between the claimant insurer and the defendant. Mr. Berry for the bank appeals against the finding that Article 14 did not apply to the claim because of the absence of economic imbalance between the insurers and the bank. Mr. McDonald-Eggers argues against the finding that the subject matter of the claim relates to insurance and defends the exclusion of Article 14 on the ground that the bank was not the weaker party. And then at paragraph 33, the submissions of Mr. McDonald-Eggers are set out, including reference to the Brogsit case. And at paragraph 34, Lord Hodge rejects Mr. McDonald-Eggers' submissions and states that that is for 6 reasons. And your lordships see those 6 reasons which are set out in 35 to 41 of his judgment. Perhaps if I can ask your lordships to read those 6 paragraphs.
Well, all those go to the question whether it's a matter relating to insurance, don't they? He only turns to weaker party at paragraph 42.
No, your Lordship is quite right. I apologise. And he then turned to the formulation in the Vorarlberger case and indicated actually that, made reference to Lord Justice Gross's reasoning that the Section 3 protections should not be extended to persons for whom the justification, the weak party justification, was not justified. And Lord Hodge disagreed with that conclusion. And sorry, these were the 6 reasons that I had in mind, which are set out in paragraph 43. So perhaps I can ask your Lordship just to read paragraph 43. So Lord Hodge then goes on to essentially expand on each of those 6 reasons in the following paragraphs of his judgment. But I hope I can summarise the point by saying that if one goes to paragraph 50 of his judgment, then he concludes that the relevance of recital 18, which is the recital which states that the purpose of the section is to protect the weak party, is where it is sought to extend the protection of section 3 beyond the policyholder, the insured, the beneficiary, and the injured party. The logic of the Supreme Court's decision was that essentially those 4 categories of parties were deemed to be weaker. The question is, if the relevant party does not come within those 4 categories, can the protection of section 3 then be extended to a party not within those categories because that party is a weaker party within recital 18? Now and in the context of the particular case, in the context of the decision at the Atlantic Conference, then because the bank was the lost payee under the policy and was therefore the beneficiary of the policy, then when it came to the relevant article, which is Article 14, which I'll take your Lordship in a moment or two, that's the article which defines the courts in which the insurer may sue the various named categories of defendant. And the article states that the insurer can only sue defendants in the courts of their domicile, whether the defendants are insured, policyholders, or beneficiaries. And so in the context of the bank in this case, the bank was a beneficiary because it was a lost payee. Ergo, under Article 14, the insurer could only sue the bank in the courts of its domicile, which was outside the UK. The relevant question for present purposes is whether a situation in which the states are not policyholders, insureds, or beneficiaries, so as to come within the express terms of Article 14. Nevertheless, because they are an injured party at least when they are making a claim, and have thus been held by the Court of Justice to be entitled to the protection of Section 3 as claimant, whether actually as a defendant the states are entitled to the benefit of the protection of Section 3, which must, in my respectful submission, turn upon whether they are being sued as injured parties, because if they're not being sued as injured parties, in their capacity as injured parties, there is no reason to extend the benefit of Section 3 to the states. And if they are not actually within Section 3, whether there is any good reason to extend the benefits of Section 3 beyond the named categories because of the provisions of Recital 18 to the regulation, which depends upon whether or not, by analogy, the provisions of that section are to be extended to the states. And that depends upon the test that falls to be applied in determining whether a party that is not within the named categories of parties in the regulation should be treated as a weaker party so as to be entitled to claim the benefit of Section 3 of the regulation. I hope that's clear as a submission. So, if we start with the relevant provisions of the regulation, then start with the regulation itself, which your lordship is in bundle B1 at tab 1 to 2, sorry, recast. Thank you. And the relevant sections for present purposes are at page 351, oblique 8 and 12. So Article 10 is the general article stating that jurisdiction is to be determined in accordance with the provisions of this section. Article 11 then sets out where an insurer domiciled in a member state may be sued. Then Article 12 states that in relation to liability insurance or insurance of immovable property, the insurer may in addition be sued in the courts of the place where the harmful event occurred. So those are all dealing with where the insurer may be sued. And in Article 13, in respect of liability insurance, the insurer may also, if the law of the court permits it, be joined in proceedings which the injured party has brought against the insured. Articles 10, 11 and 12 should apply to actions brought by the injured party directly against the insurer, where such direct actions are permitted, and if the law governing such direct actions provides that the policyholder or the insured may be joined as a party to the action, the same court shall have jurisdiction over them. So again, Article 13, 71 and 2 deal with actions brought against the insurer. Then Article 14 is the relevant article for present purposes. Without prejudice to Article 13.3, an insurer may bring proceedings only in the courts of the member state in which the defendant is domiciled, irrespective of whether he is the policyholder, the insured, or a beneficiary. So pausing there, then the categories of defendant expressly catered for by Article 14.1 are the policyholder, the insured, or a beneficiary. course, in our case, then the states are not policyholders, they're not insurers, and they're not beneficiaries.
Is it common ground that they're not beneficiaries?
It was argued by Mr. Young. You'll recall the judge's phrase that it was argued somewhat less enthusiastically by Miss Dilnot that the states.
Tentatively was the word.
Tentatively, yes, but far less tentatively by Mr. Young. They were beneficiaries. I would submit they clearly are not beneficiaries of the contract. The bank in the Atlantic Confidence was a beneficiary because it was a named lost payee under the policy. Here, actually, the states are suing in their capacity as injured parties, which is a defined separate term under the regulation. They're not obviously named in any sense in the policy itself. So, in my submission, they are not beneficiaries, insofar, therefore, as they claim the benefit of this section of the regulation must be in their capacity as injured parties.
And are they not someone who claims to be entitled to the benefit of the contract by reason of a provision of Spanish law?
They are, but that actually is dealt with specifically by the provisions relating to direct actions, where the law of the relevant country permits such direct actions by injured parties. So that is Article 13.2, which deals with that situation. So the injured party is given the same rights as other parties, specifically by 13.2, but when one gets to actions brought by the insurer against defendants, then the injured party is not one of those parties.
I think you would accept from what you've said so far that if the insurer wanted to bring a claim against an injured party for a declaration of non-liability,
Yes.
then the injured party would get the benefit of Article 14,
Yes.
because he's sued in the capacity as injured party.
That's right.
You say this is different.
That's right. And I was going to give exactly that example of a claim which might come within the aegis of Section 3, being a claim for negative declaratory relief against an injured party, because it is that claim is simply the mirror image of the claim that the injured third party has against the insurer, and it is entitled to bring in the courts of the place where the harmful event occurred. But that's obviously a different question from the question of whether the regulation provision relating to beneficiaries, which is a separate category of party from an injured third party, should be read as extending to an injured third party, because that injured third party, by virtue of a right of direct action, is entitled to make a claim on the contract. And it's my submission that a beneficiary is limited to a party that is denominated in the contract as someone who is entitled to the benefit of the contract, not someone that is given that right by virtue of a provision of local law, even though a party might be given that right by a provision of local law and be entitled by virtue of being an injured party to exercise a claim under Article 13.2.
Can I try a point that's troubling me? And it may very well be this is a result of looking at too much through an English lawyer's eyes. But the three categories of person, policyholder, insured or beneficiary, appear in Article 11 in relation to those who are suing, and appear in Article 14. We only get, don't we, the expression injured party in Article 13.2, which extends or extends Articles 10, 11 and 12
Yes.
to direct actions. So pausing there, as an English lawyer, one might think, well, injured party is simply a sweep-up expression to mean policyholder, insured, or beneficiary, but nobody else. We're told that's not so by the European Court, and that for the purposes of Article 11.1, there's another category of injured party, which by reference to recital, whichever it is, 18, may also come within 11.1b. If I'm right so far, I'm not quite sure why an injured party who comes within 11.1b and is therefore treated as within the expression policyholder, insured or beneficiary shouldn't also be treated as within that provision when it appears in Article 14.1.
I'm not sure I'm following your Lordship's question. When you say we're told by the European Court that the provision in 11.1b extends to an injured party, which European Court decision is it?
Well, I was taking that from what Lord Hodge said as a summary of
yes.
in paragraph 43 of the Atlantic Confidence. That's not right.
No, I'd submit it is not right. What Lord Hodge was saying is that in determining whether somebody is a weaker party and in therefore construing Section 3, then parties who are making claims, as in third parties who are making claims as injured parties, are within the scope of the protection of Section 3.
Where does the concept of a weaker party come? It's not an expression in the
well, it's in
the regulation,
18, and it's the justification for the entire section.
Yes.
And so European law views insurers as stronger parties and assured policyholders, beneficiaries, and injured parties as weaker parties. Full stop. And as the Supreme Court said in the Atlantic Confidence, then European law says there's no room for actually any examination on the facts of whether the relevant party is in fact weaker or stronger.
If they are policyholder, insured, or a beneficiary. But if they are a weaker party outside that scope, then there is room for looking at whether they are genuinely in the position of being weaker or not.
Well, I was going to come back to that. That's a sentence, my second limb, if you like, because the first question is whether an injured party qua defendant outside the scope of a negative declaratory relief claim, which is not really which is a claim of a very specific sort, because it is the obverse side of it, the positive claim that the injured third party has qua weaker party. If you have a claim against somebody not in their capacity as injured third party, then the question would be, does Article 14 have the result that that claim has to be brought against that party, even though Article 14 only talks in terms of three different categories of defendants. Now, if one looks at the scheme of the regulation, Article 11 talks in terms, Article 11.1b, as your Lordship has correctly pointed out, talks in terms of insurers being sued by policyholders, insureds or beneficiaries in the place where the claimant is domiciled. So that is, again, limited to policyholders, insureds or beneficiaries. Article 12 adds the right to make a claim against the insurer in the courts of the place where the harmful event occurred. Then Article 13 introduces the category of injured third party where there is actually a right of direct action granted by the national law in question, and extends the benefits of Articles 11, 10, 11 and 12 to such injured third party making a claim where the law of the relevant country permits the making of a direct action claim by such injured third party.
Injured party thereby meaning something which is not confined to a policyholder, insured or beneficiary.
Right. So,
but But Article 14(1), you say policyholder, insured or beneficiary is a closed category and doesn't include other injured parties.
Right.
But why so?
Because of the fact that, unlike the situation in relation to claims against an insurer, where there is a specific provision of the regulation which extends the rights of or the rights to sue an insurer in particular places to the injured third party, there is no such extension in relation to the Article 14 situation, which is the article which deals with the case that we are concerned with, namely claims brought by insurers. So
that's presumably because it wouldn't ordinarily occur that there would be claims by an insurer against an injured party.
Absolutely. And indeed, that's one of the puzzling things, is that one actually asks oneself, well, when is it that an insurer is likely to be suing an injured third party, other than, for example, in the example my Lord Justice Bales has given, in an action for negative declaratory relief against that injured.
What about a claim for premium?
Sorry?
What about a claim for premium?
Well, the injured third party won't owe premium. The injured third party is
No, sorry, in a three-party situation, I understand that, but Article 14 must apply in a two-party situation, obviously.
No, Article 14 does.
And
What I'm saying, my Lord, is my Lord Justice Phillips' question, I think, was directed to the situation of when you might have a claim by an insurer against an injured third party. And if I've understood the question correctly, and my answer to that is that the only circumstance that one can contemplate in which you might have an action by an insurer against an injured third party is in an action for negative declaratory relief, because it's only in that situation where the third party would be being sued in its capacity as injured third party, which is the capacity in which it is granted the protection of Section 3 of the regulation.
I understand that point, but can I just come back to my two-party situation?
Of course.
Because it strikes me as slightly puzzling that Article 14, which seems designed to make sure that assureds have the benefit of their home court if they're sued by an insurer, if they are policyholders, insureds, or beneficiaries. If there's another category of, I was going to say assured, that's not the right way of putting it, but an injured party who is affected by 14(1), you say that they're not expected to have the benefit of their home court because essentially they've only got that status as an injured party outside being a policyholder, insured, or a beneficiary because of some special third-party right of suit.
Yes. I mean, essentially, then, what I say is the regulation means what it says, and it is drawing a distinction between the three categories of parties who will be a party to the insurance contract: policyholder, insured, or beneficiary. And on the other hand, someone who is not a party to the insurance contract but is able to take advantage of rights under the insurance contract by virtue of statutes of direct action insofar as the relevant countries grant rights of direct action to injured third parties. And that's not actually a surprising conclusion if one asks oneself, well, given that the intention of the provisions of Section 3 is to protect weaker parties, then the supposition of the draftsman is that those people who are assured, to use your lordship's terms, and policyholders, insured, beneficiaries, will be weaker in the normal case. There are obviously exceptions to that, which are then provided for in Article 15, directives, then the draftsman of the regulation took the view that those parties could look after themselves. And so you were able to depart from the jurisdictional provisions of Section 3 if you fell within that category. But insofar as one is asking, well, who is it that deserves the protection of Section 3 outside the parties to the contract, the regulation says the third party is bringing claims based on rights of direct action. Let that be so, but it doesn't say claims against third parties who may be injured parties where those claims are not actually in respect of the status of those third parties qua injured parties.
I wonder whether there isn't a simpler approach to this, which is that the first question, which you've already addressed us on, is whether this is a matter relating to insurance. If it isn't, well, that's it. But if it is, then Article 10 tells you that jurisdiction shall be determined by this section, and it has two specific exceptions to that. And within Article 15, there is permission to depart, but only in the circumstances they're set out. So if this is a matter relating to insurance, there is simply no provision for an insurer to bring a claim other than Article 14.
Well, Lord, I would submit not so, because if the position is that there is a claim which an insurer has against a third party, and that third party, or that claim is not against the third party qua injured third party, this may be making a logical point in a slightly more long-winded way, then it may be that a claim which falls out with a claim against that party in its insurance capacity, i.e. in its injured third party capacity, is simply not an insurance claim.
Well, yes.
That is at least consistent with my submission that the regulation means what it says by defining the sorts of claims that come within Section 3, and a claim made by an insurer which is not against a policyholder, insured or beneficiary doesn't come within Section 3. Ergo, it might equally be argued it is clear that it's not an insurance claim.
Yes. All right. Well, your submission, I think, is that the critical question is whether the states are sued in their capacity as injured party, but I mean, aren't they sued in your judgments claim as parties making a claim under a liability insurance policy? That's the whole thrust of your complaint, but that's what they're doing when they shouldn't be.
Well, again, my lord, this comes back to the same point I think that I've already
Say in the wrong forum.
Yes.
Well, their capacity as injured parties making a claim in the wrong forum.
Well, I would say again, it does come back to the point as to whether the gravamen of the charge is that they're making their claim in the wrong forum, as opposed to the gravamen of their charge is that they're making an insurance claim.
Yes. Okay.
Could I just understand?
I'm sorry, I'm being prompted, my lord. If I can just answer your lordship question first.
All right. If there's something you want to add.
You were going to ask me a question.
No, my lord was going to.
It was me, sorry. Can I just go back? I may not have understood something. Where an insurer brings a claim seeking a declaration of non-liability against an injured party,
yes,
you accept that that would have to be in the domicile of the injured party.
yes.
Why is that?
Because Essentially, otherwise it would be a simple way of getting out of what are intended to be mandatory provisions of the regulation.
Well, doesn't that rather point to the proper interpretation of Article 14?
Well, I would submit not, because the reason that I would accept, I think would have to accept, that an action against the injured party, qua injured party, or negative declaratory relief, which is simply the mirror image of the injured party's right to sue, would have to be brought in the country in which the injured party has that right to sue, because otherwise that would drive the coach of horses through the provisions of the regulation. Not so if the claim in question is of an entirely different sort, in which case then, again, purposefully, and one has to read this regulation purposefully, because as with any other EU regulation, that is how we are adjured to approach the construction of European legislation. The purpose of this section is to protect weaker parties in certain fact situations. One of those fact situations is where there is an injured third party who wishes to bring a claim in respect of that injury in the courts of that party's domicile. That is a relevant fact situation. So, purposefully, to hold that an insurer was entitled to preempt that right by bringing the same claim somewhere, or the opposite of that claim somewhere else, and then saying, I have now actually scotched your entitlement.
I understand that. But the question is, the easy answer to that, and I think this is the point my Lord may have been making, is that one can deal with this simply by saying that Article 14 does apply in that situation, unless the matter doesn't relate to insurance.
Well, Lord, I would submit you're then actually, in a sense, one is saying that an insurer can never bring an action against a party, even if that party is not an injured third party. The action's got nothing to do with the status of the third party, qua injured third party. What actually is then said is that because of the provisions of Article 14, which don't say this, then the insurer can't bring an action anywhere else. Now again,
that's clearly what Mr. Justice Butcher said. He said the important thing is the word defendant.
He did, and my submission on that is that what he didn't do is to go on to look and see what the regulation says, which is that it defines the types of defendant.
Well, it doesn't. I mean, I think when you summarise what it said, I'm not sure you focused on the word irrespective. Mm-hmm. As you say, it's looking primarily at the fact that defendants are going to be policyholders, insured, or beneficiaries. But it's not the clearest of wordings to say that the defendant can only be policyholder, insured, or beneficiary.
Well, my Lord, although the word irrespective is used, what then follows irrespective are three named categories. So say irrespective of whether it is A, B, or C. That doesn't mean brackets or D come with that. With great respect.
Well, it may do in language where A, B, and C are the definition of those who are covered in Article 11, but actually there is outside, and as a teleological approach, the fourth category, injured party,
yes,
as well.
Again, I come back to my point, my Lord, which is that there's a teleological approach.
Well, I understand that. And as I understand it, if one's just looking at the language of Article 14,
yes,
you don't say that irrespective of means. Sorry, you don't say irrespective of whether he is means irrespective of whether he is or is not, i.e., go no further. I thought you were saying it essentially means if he is the policyholder, the insured, or a beneficiary. So that if he's not one of those threes, Article 14 just doesn't bite at all. But your suggestion that Article 14 does bite on an injured party, if it's a claim for a declaration of non-liability, leaves me floundering a bit as a matter of language as to what you say it means. It doesn't mean if, and it doesn't mean irrespective of one way or the other. It means if he's the policyholder, the insured, or a beneficiary, or in some circumstances, the injured party. Is that how it works?
I think the way that I would put it, my lord, is that I would have to accept, simply because of the need to adopt a positive approach to a regulation such as this one, that where the regulation gives a right to an injured third party to have a claim determined in the courts of that third party's domicile, then what, this may have nothing to do with Article 14 at all, what the insurer cannot then do is to preempt the exercise of that right by bringing a claim other than in the courts of the domicile of the injured third party. Because, as I've indicated, that would be driving a coach and horses through the regulation. The way that one would then reconcile, in my respectful submission, Article 14 is that Article 14 doesn't have to do with actions by or against the injured third party, which are dealt with in the other provisions of the regulation. So Article 14 has to do with, as it indicates, actions brought by the insurer against the three categories of defendant.
But doesn't it drive a coach and horses through it to read Article 14 as not applying to an injured party in certain circumstances? That's what you're really saying. It doesn't matter which way round you put it.
Sorry, I'm not sure that I caught it.
Well, as I understand it, what you're saying is that it must be the case that injured parties have to be sued in their own domicile for a negative declaration. And you sort of set that aside and say, look, because it's so obvious that must be the case, then it can be taken out of these provisions.
No, what I say, my lord, is that if one looks at Articles 11 to 13, those establish that an injured third party is entitled to have the relevant dispute determined in the courts of that third party's domicile. So, if an insurer seeks to, by virtue of negative declaratory relief, to escape that entitlement, then by virtue of the provisions of Articles 11 to 13, it would be held that that is an approach that is not open to the insurer.
Yes, and one of the ways you could do that is to read Article 14 to include injured party.
No, because there actually it's a limitation upon rights which the insurer has to bring claims against. Put it another way. One of the ways you could do that would be to read Article 14 in that way. The question is whether, firstly, you need to do that in circumstances which, in my respectful submission, it would be doing violence to the terms of Article 14, and in which you don't need to read Article 14 in that regard in order to achieve the result that the regulation would dictate should follow, because of the fact that Articles 11 to 13 are sufficient unto the purpose. They make clear that actions by relating to the claim by an injured third party must actually conversely, actions under Article 14 have to do with the insurer's claims, and those in general terms will be against the three named categories of defendant. And our quarrel with Mr. Justice Butcher's judgment is that he stopped at the word defendant, and he didn't actually go on to consider whether the words which went which appear thereafter qualify defendant, so that it is only where the defendant falls within one of those three categories that the article applies. My Lords, unless I can give any further assistance in relation to that point, then I was going to move on to the next point, and that is the question of whether the states are indeed weaker parties, insofar as that it is a relevant question.
And what's the hypothesis on which that question arises? That the states are injured parties but are not sued in that capacity. Is that the scenario in which that consideration arises, or is it something else?
Rises on one, I think, of two alternative scenarios. One is that the states are not sued in their capacity as injured parties, and the second is that they are sued in their capacity as injured parties, but Article 14.1 does not actually apply to suits against injured parties.
I thought you accepted in the last submission that it does apply if you are sued in the capacity as injured party.
I think about that.
That appeared to be, perhaps I missed it, but that appeared to be the whole thrust of your submission on the last point.
Well, the thrust of my submission on the last point was certainly that it was necessary to ask whether the states were sued in their capacity as injured party. But I was also then, I think, in my answers to my Lord Justice Popplewell's and my Lord Justice Phillips' questions, addressing the question of whether Article 14.1 meant that even if they were sued in their capacity as injured third parties, nevertheless Section 3 would apply to them.
Right.
And this may be putting the same point in a different way, because I would have to accept that insofar as a claimant is an injured third party, then as the Supreme Court said in the Atlantic Conference, that claimant is deemed to be a weaker party.
Yes.
In respect of its claim. But obviously here we are concerned with the relevant party as a defendant, not a claimant. So the two hypotheses may come to the same thing. But then the question is, if the states are sued otherwise than as injured parties, or if the nature of the action doesn't fall within Section 3, then are the states weaker parties?
So if they're not sued if it's not within Section 3, the weaker party question doesn't arise, does it? You simply either get jurisdiction under one of the other provisions of the regulation, or you don't. I mean, it's interesting to debate whether the states are a weaker party, but I'd like to be absolutely clear as to
Yes.
precisely when that will matter.
Well, it matters in relation to at least one aspect of the case, and that is the subrogated claims aspect. Because insofar as the states are bringing subrogated claims, then the authorities suggest that a subrogated party who is not itself an injured party may not be a weaker party and entitled to the benefit of Section 3 of the regulation. And the way that this has been approached in the cases is that the cases have drawn distinctions, in particular between professional insurers and others. If I can show your lordships briefly the relevant authorities.
I think it's perhaps insurance professionals rather than professional insurers is the distinction that's drawn, isn't it? So for example, a claims manager who took over claims.
Yes, the Hosso case was the claims manager who
Yes.
who effectively took assignments of claims and then pursued the claims to which he was subrogated.
Yes, and it didn't matter that he was in a small way of business and therefore
It didn't matter
personally
that he was in a
weaker.
small way of
He
business
was.
because he knew what he was doing, and in those circumstances he wasn't entitled to the benefit of the section.
Yes. Right. Okay.
So it's clear that your lordship is very familiar with the cases, but perhaps if I can just show your lordships those three cases very briefly.
Yes, of course.
And just to set this in its proper background, as your lordships know, then firstly, your lordships know that at this point it applies only to Spain and not France. Secondly, then in terms of the scale of the point, then some 49.5% of these claims which Spain were pursuing were subrogated claims. And those claims arose by reason of the fact that Spain, by virtue of a royal decree that had been passed at the time, paid compensation to third parties. So that in turn gives rise to a further issue because of the fact that a party who is subrogated to the rights of other injured parties is not automatically a weaker party and is only entitled to the benefit of Section 3 if that section can be extended to that party. And the case law is discussed, European case law is discussed in the Atlantic Conference, again in the Supreme Court, at paragraphs 50 to 56. It may be easiest to take the relevant references from that discussion.
Yes. Just to understand the facts, though, you told us that 49.5% of the claims were subrogated
Yes.
in the case of Spain. That's 49.5% of the total claims which were advanced, whereas the liability was capped at $1 billion or its euro equivalent.
That's right.
But were those claims allocated so that, as it were, 49.5% of the $1 billion goes to the subrogated claims, or was that just left at large?
That is still at large. Indeed, it's an issue that is to be determined by the courts of this country, because or potentially to be determined by the courts of this country. It's an issue which was at the CMC in the enforcement proceedings, effectively adjourned to be dealt with in the light of the enforcement or registration proceedings, because the various different claimants, including both Spain and France and the various individual claims, will all have claims against the overall fund, the $1 billion, or in fact 855 million euros, because the way it worked was the policy limit had deducted from it the CLC limit, because the CLC fund had been constituted in Spain by the club.
Yes.
So that amount of 855 million euros was sitting there as a pot. There will then need to be a determination of who is entitled to enforce against that pot and how that pot should be allocated. In terms of Spain's claims, then there hasn't been any allocation as between the Spain's original claims, as it were, and the subrogated claims. The totality of the claims that Spain is pursuing includes both subrogated claims and its own claims.
Yes.
And those claims in their totality will have to be enforced against the limited fund, along with all of the other claims, including France's claims and the claims of the other individual claimants.
Yes.
Irrespective of allocation, presumably there'll be a no-loss argument, because the non-subrogated claims, as I understand it, were for more than the cap, for more than the 1 billion. Is that right?
The non-subrogated claims,
the direct claims, were for more than $1 billion. So if I got this right, the consequence of this is that, if you're right, you may be left with an ability to pursue a claim for breach consisting of the pursuit of the subrogated claims, but not the direct claims.
Yes.
And if that's the only breach of which you're allowed to complain, will that have caused you any loss in circumstances in which the same liability would have arisen on the direct claims, which you're not entitled to complain of breach?
Allocation,
why is it allocation? It's the club's loss in having to constitute the fund. Doesn't matter what the fund's allocated to, does it?
No, it's the club's loss actually is arising out of how much of the claim is a claim which should not have been pursued. And so if the position is, the argument that is being taken is that if Spain was not entitled to bring its own claims,
Yes,
then that itself would be a breach by Spain of its obligations.
No, I understand. I'm wrong about that. Yes.
My Lord, if I can then take your Lordship to the Atlantic Conference, which, as your Lordships know, is at tab 51 of bundle A5. And the relevant paragraphs are paragraphs 50 to 56. In particular, 51 to 56. This is in relation to Lord Hodges' fifth point, and what he is here considering is that the Court of Justice, as regard to recital 18, when it is asked to extend the protection of section 3 beyond the policyholder, the insurer, the beneficiary, and the injured party. So in paragraph 51, it makes reference to the Group Josie case, which was a dispute between a reinsured and a reinsurer. Court held that a reinsurance contract could not be equated with an insurance contract, and the protections afforded to policyholders could not be extended to a reinsured. And the CJEU stated in paragraph 65, the the role of protecting the party deemed to be economically weaker and less experienced in legal matters than the other part of the contract, which is fulfilled by the provisions of Section 3, implies, however, that the application of the rules of special jurisdiction laid down to that end should not be extended to persons for whom that protection is not justified. And then the same approach was adopted in Groupement d'intérêt économique Réunion Européenne, case which concerned an attempt by an insurer to bring Zurich Hispania into the action as a third party on the basis that it had also covered the loss in question. The dispute was as to whether Zurich could invoke the protection of what is now Article 14, requiring it to be sued in the courts of its domicile, or whether the insurer could invoke the third party jurisdiction in Article 8.2 of the regulation. The CJU repeated the formula in Group Josie, quoted above, and spoke of the authors of the Convention having taken as their premise that the provisions of Section 3 applied only to relations characterised by an imbalance between the parties. He went on to say at the end of that paragraph, thus, again, the CJU invoked a policy of protecting the weaker party, not to look behind the categories of persons expressly protected by Section 3, but to ascertain whether that protection should be extended by analogy to persons who are not expressly protected.
So in our case, that question would arise in relation to somebody who is not himself an injured party, but is pursuing an injured party's claim by way of subrogation.
Right. And then in Vorarlberger, perhaps I can just ask your lordships to read paragraphs 53 to 55, which deal with the three cases in question. So your lordships will see that the Court of Justice have essentially dealt with this point in a number of cases, and we have to say that it's quite difficult to elicit a clear principle from those cases. The earlier cases quite clearly do actually look to the question of whether or not the party is in need of protection of the section, and look to the question of whether that party has relevant expertise in relation to insurance. In Vorarlberger, then the Social Security institution wasn't permitted to obtain the benefit of the Section 3 protection. In Cabeg, then the public law establishment which ran the private hospitals was actually permitted to obtain the benefit of Section 3. Even though that did involve an extension of the provisions of Section 3 to a party who was not an injured party, that party having actually compensated an injured party. Although it may also be said that the employer had suffered its own loss in that case. And then finally, in Hofso, then the benefits of Section 3 were not extended to the claims handler, is the one that my Lord Justice Mayles was just referring to, where the claims handler clearly was in business, dealing with insurance claims and in business effectively pursuing insurance claims on behalf of other third parties. Notwithstanding the fact that that claims manager was in a small way of business rather than in a large way of business. In our case, obviously, the position is that the Spanish state has taken it upon itself to set up an insurance regime pursuant to the royal decree. It is therefore acting, in my submission, in its capacity, in a capacity as an insurance professional. And in those circumstances, in relation to the subrogated claims that it has obtained by virtue of paying out pursuant to that statutory scheme of insurance which it established, it is not entitled to the benefit of Section 3 in relation to those claims.
It's a slightly unusual insurance regime to be established after the casualty has occurred.
It is, but in a sense, it's no more unusual than a claims handling situation, where a claims handler decides to take the benefit of, or to seek to take the benefit of claims as part of the exercise of its business. Yes, your Lordship is quite right in saying that here actually this was an after-the-fact insurance that was set up, but nevertheless actually it was an insurance regime that was set up by the state.
But I mean, the reality is that it was a scheme set up by a state to protect its citizens from or mitigate the consequences of an environmental disaster. Sounds a bit statish rather than insurance-ish.
Well, your Lordships have my submissions in relation to the point. The question I would submit is whether in those circumstances in relation to the claims that the state has voluntarily assumed by virtue of that scheme, the state is entitled to the benefit of a section which is designed for weaker parties. In a sense, it's an odd proposition to say that a sovereign state is a weaker party for the purposes of this type of inquiry.
Well, I was really focusing on your submission that the state was acting as an insurance professional. I mean, so far as the cases are concerned, is it possible to derive any greater principle from them than that insurance professionals don't get the protection of Section 3? So far as others are concerned, you need to carry out an assessment of the character in which they're acting concerned with, for example, if somebody is an employer, whether they're an employer of thousands of people or small numbers, so you're not concerned with their particular circumstances in those in that case. You look at the category or character of the party concerned and form a view somehow or other whether they qualify as a weaker party.
Yes. Well, I certainly don't submit that there are any clearer principles that can be drawn from those various cases in the European Court.
Yes. I mean, if the Advocate General in Quebec had been followed, it would be insurance professional or bust, but that's not what they said.
No.
Okay, thank you.
Just before we leave this section of the Atlantic Confidence, in paragraph 57 at the end of this section, in the last sentence, Lord Hodge says, and he's dealing with derogation from the primary rule of domicile, Article 14, which requires the insurer to bring proceedings only in the courts of the member state of the domicile of the insured, involves no such derogation, but on the contrary supports the general principle. And I think it follows from your earlier submissions on Article 14 that he was wrong to say that, because in some circumstances Article 14 is not exclusive, and therefore there can be a derogation from the principle of suit of the state of domicile.
Sorry, my lord, I put the report away.
I'm so sorry. It's tab 51 of volume 5, and it's page 538 of the report, paragraph 57 of the
I'm grateful.
judgment I was looking. And it was really the last sentence, except of course that this case was concerned with claims by the against the insurer.
I think the point that was being made there, my lord, is that the general principle underlying the convention or the regulation is that the specific examples given in the text of the regulation, the various different titles, because they are exceptions to the general rule of domicile, which is the rule established as the default rule under the regulation, have to be construed strictly. His point was that in relation to Article 14, because Article 14 reinforces the general rule in the regulation, then there's no requirement to read Article 14 strictly, because of the fact that, at least on, yes, only on the facts of that case, because of on the face of things, then Article 14 is requiring the defendant to be sued in the same place as the general provisions of the regulation would require the defendant to be sued. I would submit that doesn't really assist in relation to the proper construction to be placed on Article 14.
All he's saying is that Article 14, where it applies, as an example of something which doesn't involve derogation.
Yes.
Not Article 14 is in relation to the section as a whole.
Yes.
In matters relating to insurance.
It's simply saying you should
non-derogation.
read Article 14 as in some way a derogation from the general rule because it's reinforcing the general rule. And the general rule is that a defendant is entitled to be sued in the courts of that defendant's domicile.
All right, thank you.
My Lord, can I go back to my Lord Justice Males's question in relation to the hypotheses that one was addressing these questions on? And in our submission, the logical order of the questions that we would submit one needs to ask are, firstly, under this heading, whether Article 14.1 is only available as against the three categories of defendant, i.e. policyholder, assured or beneficiary. Secondly, if the answer to that question is no, is Spain a defendant to whom Section 3 applies? If it is sued as an injured party, the answer to our first question is no, then the position would be that Section 3 would apply. If it is not sued as an injured party, Section 3 would not apply. And then lastly, the question of subrogation, i.e. is there a distinction to be drawn between the state's own claims and the claims which the states bring by way of subrogation?
So I should just clarify, France doesn't bring claims by way of subrogation. It's not states.
I beg your pardon. Sorry, I thought I made that clear earlier on. Our learned friend's quite right. It's only Spain that the subrogation point applies to. And lastly, are the states weaker parties in relation to the
Spain.
Sorry, Spain weaker parties. My lords, turning to the judge's judgment in relation to this issue, then on the subrogation, the judge actually accepted the club's case on subrogation. At paragraphs 133 to 137 of his judgment. At 401. Actually, you'll see he comes to his conclusion that states or other public bodies which set up statutory compensation schemes will fall within the type of entity which of its nature is not a weaker party. But he then actually went on to find that notwithstanding that conclusion, that the subrogated claims and the non-subrogated claims were both to be tried in Spain.
So the judge's conclusion was not based on Spain being equated to an insurance professional, which is the way that you put it, but rather on the fact that it being a state setting up a statutory compensation scheme.
Yes.
Yeah. Okay, yes. Two different capacities.
But I would submit that the judge was right in his conclusion, albeit based upon that different ground as to the position of Spain as a state that had set up a statutory compensation.
Oh yes, you don't mind how you get there.
I don't mind how I get there. What I would submit though is he was wrong then in his conclusions, if you like, by reference to which he consequence of that conclusion, which are set out in paragraph 138 of his judgment. He started from the proposition which I certainly find it difficult to argue with, but that it would be undesirable to have two related points tried in different courts. But his rationale for holding that the subrogated claims should not be tried in England was twofold. Firstly, he said that if a party is an injured party, then it must be regarded as an injured party, even in relation to that party's claim in respect of which it is not an injured party. And I would submit that that cannot be correct. Secondly, he held that that was so at least where the claims of the state qua injured party were greater than the subrogated claims. And again, I would submit there is no principle, or indeed good policy reason for adopting such an approach. The fact of the matter is that one has to just ask whether the claims in question are actually within the relevant provision. If some of the claims are and some of the claims aren't, then it cannot be right just to say because more of them are than aren't, then they should all be treated as within the relevant provision. And that's particularly so because, firstly, it's difficult to see how one is supposed to determine, is it by value or by number of claims? Secondly, when is one supposed to determine that question, given that this question will arise at a jurisdictional stage? So if a party, for example, inflates one part of its claim, which is then within the relevant provision, so as to say that the majority of its claim is one which falls out with the scope of the regulation, then thus bringing about a situation in which jurisdiction is declined, and then I would submit that that would clearly be an approach which should be avoided if at all possible. So an approach which essentially says even if part of these claims are not actually within the relevant provision of the regulation, nevertheless they should be treated as being within that provision because they are the lesser part of the claims, is not a well-founded approach and should not be adopted by this court.
Just analysing that in terms of your cause of action, and you may say this again is not a proper European approach, but the cause of action in the judgment claims is for the breaches which are comprised by the Spanish proceedings, to put it loosely, which may be characterised on the one hand as a single breach in bringing the proceedings involving all these claims.
Yes.
Or it may be characterised as a series of separate breaches in relation to each claim or each category of claim that is brought. And from a domestic point of view, we're used to allocating jurisdiction by reference to the ingredients of the cause of action. So that would be determinative, as it were, that characterisation. Do you say that the breach in this case was a series of breaches which are to be characterised by reference to the individual claims that were made within the proceedings?
No, I don't say that, my lord, because certainly if one goes back, way back when, to 2013 and this particular distinction between claims which were being brought by Spain on its own behalf and brought pursuant to subrogated rights was not one which had been adverted to at all. The position was that there was a single claim being brought by Spain for a total amount of money, and it was that claim which the earlier award and judgments indicated should be brought in London arbitration. So our cause of action, I would have to accept, is referable to the breach in bringing the totality of those proceedings, both subrogated and non-subrogated, in Spain. I hope that answers your lordship's question.
Well, it's answered my inquiry as to how you put it, but does it not then lend some support to the judge's approach, provided that those proceedings involve direct claims? That is sufficient for jurisdictional purposes, and that one doesn't have to dissect what I think you say is the consequence of the distinction now, which is you should be allowed to amend your claim to prove breach only insofar as the proceedings related to subrogated claims.
Well, I can take it in, as it were, in reverse order.
Yes.
I would still not support the judge's distinction, as it were, between, or the judge's approach by way of saying that the lesser follows the greater, if you like. What I would submit is that where, to adopt your lordship's wording, where the cause of action that is sued upon.
That wasn't quite the point of the judgment I was on, because there were two bases of the judgment.
Yes.
The first of which was, if you've got some claims which fall within the regulation, it makes you an injured party, and you can bring the proceedings.
And my point, I think, my lord, is that so we're dealing with the position of Spain as an injured party here. Is that right, my lord?
Yes.
And so, as far as Spain's causes of action are concerned, then insofar as we were looking at what Spain could and couldn't bring within the regulation, then I'm sorry,
No, well, it's my fault. But what ultimately the question we're concerned with is what claims the club can bring. That's why we're looking at the regulation, and it's the breaches by, in this case, Spain, which form part of that cause of action. And one of the two ways the judge dealt with the subrogated, non-subrogated split was to say in 138, if they've got direct claims which make them an injured party, that is sufficient for Section 3 to apply. And the point that I was putting to you is, if the breach is in bringing the proceedings as a whole without any distinction
yes.
as to the claims that are subrogated and non-subrogated, does that not lend support to his view that you've got a breach here by bringing the proceedings, which at this stage of the analysis means injured party, Section 3 applies, full stop?
Well, I think I would put it in perhaps slightly, I hope that's a simpler way, and I thought that I had understood your lordship's question to be directed more or less in this regard. If one concentrates on the club's claims and the cause of action that a club is relying on, then the club's claims are indeed for a failure to abide by the obligation to bring all of the subrogated or not in arbitration. So the breach on the part of Spain is in failing to bring all of their claims in London arbitration, and it matters not whether those claims were subrogated claims or original claims. But in terms then of looking at the regulation, then the question is whether or not the claims which are being brought by the club are insurance claims, and to some extent the claims brought by the club are insurance claims if, on this hypothesis, one part of the club's claims relates to actions which are brought by Spain qua injured party on its own account, and one part of the club's claims relates to claims which are not brought by by Spain qua injured party, because they are brought by way of subrogation, and in those circumstances, Spain are not entitled to the protection of Section 3, so as to be required to be sued in respect of the club's claims in Spain.
Isn't it the other way round, that assuming we were against you on all the points so far, so the Brussels regulation applies, it's within Section 3 and so forth, but we get to the position where some of the claims being brought in Spain fall within Section 3 and others don't, but nevertheless the claim which the club has brought, which extends to all of the claims, is one for which this court doesn't, on this hypothesis, have jurisdiction, notwithstanding that it might have had jurisdiction if you had brought claims confined to the subrogated claims in Spain.
Well, then the question would be, my lord, whether the court should essentially strike out the claims in respect of which, or say that it doesn't have jurisdiction in relation to the claims that it does have jurisdiction over, because the club has brought claims in respect of which the court doesn't have jurisdiction, on your lordship's positive, as I understand it. So the position would then be that the court would have got to the stage of saying, well, had you brought a claim which was limited to a claim for breach of the obligations not to bring the subrogated claims, then actually this court would have had jurisdiction. But because you brought a claim which goes beyond that and extends to the totality of the claim that Spain has made, including both the portion of the claim which is subrogated and the portion of the claim which is not subrogated, then this court doesn't have jurisdiction. And I would submit that that can't be right, that either the court has jurisdiction in relation to the claim or part of it, or the court doesn't. But I would say that it would be wrong to effectively say go one, go all, and say unless the court has jurisdiction over the totality of the claim, it doesn't have jurisdiction over any of it.
Yes, okay. Right, where do we go next?
My lords, then I was going to move on. I was going to come back to Article 14.2 of the regulation, which is the counterclaim provision. The reason I was going to come back to that is because 14.2 is the same, essentially in the same terms as Article 8.3 of the regulation. And Article 14.2 applies where there is an insurance claim and gives the court jurisdiction relation to a counterclaim to such a claim. Article 8.3 is the more general counterclaim provision within the regulation, which is the jurisdiction where there is a counterclaim of what is. And so I was going to move on to the more general considerations that arise on the hypothesis that the matter is outside the insurance provisions of the regulation. The first relevant provision outside the insurance provisions is Article 7.1 of the regulation. And that is the article that deals with contractual obligations. And again, if I can ask the Lordships to turn up the regulation, which is at Article B1 tab 2. Article 7.1 is at page 7 internally of the regulation. It provides that a person domiciled in a member state may be sued by another member state. 1A, in matters relating to a contract, in the courts for the place of performance of the obligation in question. Then under B, for the purposes of this provision, and unless otherwise agreed, the place of performance of the obligation in question shall be, in the case of sale of goods, the place in a member state where under the contract the goods were delivered or should be delivered. In the case of the provision of services, the place in a member state where under the contract the services were provided or should have been provided. And then C, if point B does not apply, then point A applies. So the question in this case is what the place of performance of the obligation to arbitrate in London is.
Isn't there a prior question whether the judgments claim, which is what we're talking about, is a matter relating to a contract? It's not a contractual claim.
It is a contractual claim, my lord, because one of the ways in which we put our case is that there is an implied contractual obligation to honour a judgment of the English court. That's the decision of Lord Justice Leggett in the EDF Mann and Harrianto case. And whereas here the judgment is a judgment which requires you to perform an act, viz. To perform the obligation to arbitrate, then the obligation, the contractual obligation, is to comply with the judgment of the court, which requires you to arbitrate. And then actually one asks, well, where is that obligation to arbitrate to be performed? And the answer to that question is in London.
And the contractual obligation to abide by a judgment arises simply from the fact of the judgment or from conduct in litigating to the judgment?
From the fact of the judgment. Mr. Harrianto did his level best to avoid a judgment ever being given against him by failing to appear at any stage during the course of the litigation leading to the judgment being given against him.
So what is the conduct which is said to give rise to a promise?
It is simply the fact that the English court gives a judgment which it has jurisdiction to give. That in turn gives rise to a promise as a matter of law to abide by that judgment. Then obviously the further question arises as to what is meant by abiding by the judgment, which obviously depends upon the terms of the judgment.
Right, I may have to have another look at Harrianta. It's an odd concept that you have a contract by doing and saying nothing, and simply by being subjected to a judgment. Does Justice Leggett explain that?
From recollection, my lord, not in any great detail. No, it's about a 2-page judgment.
It may well be, and if Lord Justice Leggett says it is, no doubt that is the position under English law, but it seems strange to think that that is what is meant in a piece of European legislation by a contract.
Well, my lord, the answer to that I apprehend is that what is meant in a piece of European legislation by a contract is left to the national law to decide. So, there's no definition of a contract within the regulation.
Okay.
In the sense, the only definitional point is almost negative, because one knows that 7.1 is in apposition to 7.2. So 7.2 deals with delict or quasi-delict, and one knows also from other European instruments, in particular Rome 1 and Rome 2, that there is a well-established European tradition of differentiating between, on the one hand, contractual and on the other hand, non-contractual obligations, and everything that is not contractual is non-contractual. My lord, so...
But you, just to finish on this point, you don't say that the contract arises out of participation in the Section 66 proceedings.
My lord, yes, I could say that.
Do you in your particulars of claim?
Yes, I do. One of the oddities is that this was the way in which we put our case, which Mr. Justice Henshaw rejected. He rejected it on a couple of different grounds. The main ground was because he held that the relevant dispute was not arbitrable. Because we do say that by actually participating in the Section 66 and Section 67 proceedings, then there was an implied contractual obligation to abide by the decision made by the courts in those proceedings.
But we're on the judgment claims at the moment, so that
Yes.
would be that would be the relevant contract.
Indeed. So yes, your lordship is absolutely right that there is positive conduct, and your lordship is quite right to remind me there is positive conduct which goes beyond simply the fact that the judgments were rendered, which was the case in Harrianta where there wasn't such positive conduct. So then the next question is what the place of performance of the obligation in question is. And we've set out in paragraph 164 and following of our church the relevant principles. And those are, I apprehend, common ground. I'll come back to them after a short adjournment. What I wanted to say first is that in relation to Article 7, it's important to bear in mind what the purpose of these provisions in this regulation are. And the purpose of these provisions in the regulation are to tie a particular dispute to the courts of a particular country, i.e. to justify the courts of that country assuming jurisdiction in relation to a particular dispute. It's a sort of linking factor. And under 7.1, the linking factor is the contract and where that contract is to be performed. one can see that actually from the provisions of 7.1b as well as 7.1a, because 7.1b in the context of the particular types of contract that are dealt with in 7.1b indicate, for example, in the case of a sale of goods contract, the relevant place is where the goods were delivered or should have been delivered. So where there is a non-delivery, one asks, well, what would have happened if the contract had been performed? Where should it have been performed?
Is this essentially the same point as we had, what seems like quite a long time ago now, under section 3.1b of State Immunity Act?
Yeah. It is a similar point, my lord, and I will once again be attempting to persuade my lords that the correct analysis is that the obligation falls to be performed in London. The obligation being the obligation to arbitrate, and that the suggestion that the obligation is not to do something anywhere else in the world is an ill-founded suggestion, because one's actually asking, and this is why I make reference to this, these subparagraphs. It's the counterfactual. One is asking, well, if the contract had been performed, where would it have been performed? And the answer to that question is, in my respectful submission, London. And it is because of the fact that the obligation would have been performed in London that the courts of this country have a good justification for assuming jurisdiction in relation to disputes in relation to that contract. That's why I say it's a linking factor point. My lord, just is quite right. This is a very, very similar point to that which was in relation to the State Immunity Act, because again, that's a linking factor having to do with where the obligation, which is in question, falls to be performed. Then actually, in just as I indicated I would, if we go to paragraphs 164 and following of our skeleton in Court Bundle 1. Tab 3.
The reference.
Paragraph 164.
164, thank you.
So you'll see in paragraph 164, and there's a reference also to the paragraphs of the state's skeleton 163, 165 and 168, in which the same principles are set out. The relevant contractual obligation is the obligation on which the claimant bases its claim, de Blues against Boyer. If there are one or more relevant obligations, the court should apply the maximum accessorium sequitur principale and identify the principal obligation and apply Article 71 to that obligation, Chenevi and Kreischer. Once the obligation is identified, the court must ask where the obligation is to be performed. This is to be determined by reference to its applicable law, applying the court's conflict of laws rules, in that Tessely case. The party invoking Article 7.1 must demonstrate to the standard of good arguable case that the obligation is to be performed in the jurisdiction, here England, Mercury Publicity against Wolfgang Lurker and those are the relevant principles. And we submit, therefore, that clearly the positive obligation which should have been performed is the obligation to comply with the judgment, which in turn imposes an obligation to comply with the requirement to arbitrate. And in those circumstances, if one asked where the obligation to arbitrate was to perform, the contract gives the answer to that question quite clearly. The obligation which the contract imposed and upon which suit was brought was the obligation to arbitrate in London. Might I seek also then to go back to my Lord Justice Phillips's point that was put to me on a couple of occasions yesterday, and that is that the remedy for a failure to adhere to an agreement to arbitrate in London is an anti-suit injunction. And I quite accept, of course, that proposition, though in our case that proposition may be complicated by the state's assertion that one cannot obtain an injunction against a sovereign state. But if one asks, well, why is the anti-suit injunction granted in a case such as this? The answer to that question emerges from the angelic grace itself. And the reason why the anti-suit injunction is granted is to protect the right of the party, the contractual right of the party, in this case the equitable right of the party, to have the relevant dispute determined in the appropriate forum, which in this case is the arbitration forum in London.
But we're not concerned with the right, we're concerned with the obligation. And what we've got to decide is what's the nature of the concomitant obligation. Is it an obligation to do something in London? Or is it an obligation to refrain from doing something everywhere else in the world? I know that's merely restating the point, but we're concerned with the obligation, not the right, aren't we?
Well, my Lord, what I would submit is we are concerned with, we're concerned with both. And this is why I put it yesterday by saying, if you are going to proceed, then you must proceed in London. And your Lordship put to me that, in a sense, the obligation was not to act inconsistently with the obligations which were stated to exist in the award and in the judgment. And the claims are that the states have acted inconsistently with those obligations thus declared. So, in Hofeldian terms, then the right to have the matter arbitrated in London has as its correlative the obligation to arbitrate the dispute in London, or not at all.
Well, that's it's the or not at all. It's the if. It's not a Hofeldian opposite.
I quite accept that the states, as it were, if the states had simply chosen not to pursue a claim at all, nobody could actually have complained. If the states had chosen not to pursue a claim at all, then the principle of conditional benefit would never have been brought into play. And so none of us would be here, and indeed none of us would have been here back in 2013 or 2015.
Mr. Hacker, that is the point about anti-suit injunction, though, because what the anti-suit injunction is to stop proceedings, order the party to stop proceedings overseas.
And it says that if you're going to bring your proceedings, you must do so in the contractually agreed forum.
An anti-suit injunction doesn't say that.
Well, an anti-suit injunction sometimes does say that. An anti-suit injunction sometimes does have two limbs.
But it wouldn't be an injunction then, would it?
Well, one bit of it would. The other part of it, well, they would both be. One would be negative. The other would be mandatory. In fact, if we look at the fact of this case, the award actually did have both limbs. The award said you are bound by the obligation to arbitrate, and having brought the action, you must arbitrate that claim. If you brought the claim, you must arbitrate that claim. Again, great respect, if one asks, as I say, again we are here actually on the question of what links the matter to this jurisdiction. If one asks, well, why is it that the courts of this country should have jurisdiction in relation to a dispute? The answer is because it's an English law contract imposing an obligation to arbitrate in London. And if one therefore asks, well, what is the obligation that is sued upon? It is the obligation to arbitrate in London. And that is why this court, as opposed to any other court within the European Union, has jurisdiction to deal with the issue.
And you'll be right about that if you establish it comes within the arbitration exception.
Well, I wouldn't need to be within the Brussels regulation if I was within the arbitration exception. Yes. But even if I am not within the arbitration exception, then the question remains, under the Brussels regulation, what is the obligation in question? Answer the obligation to arbitrate. Where is that obligation to be performed? And it's not actually an answer to that to say it's to be performed everywhere else in the world by not suing, but not in the one place where you were obliged, if you were going to sue, to sue. It's a very odd proposition to say that every other court in the world has jurisdiction in relation to this point, except the courts of the country in the UK in relation to an English contract imposing a London arbitration agreement. That's the conclusion that effectively your lordships are putting to me, which would have to follow from that logic. And I would simply submit that that quite clearly cannot be right, because you're then actually, you're not looking at what would have happened if the contract had been performed. You're effectively saying, well, there were lots of ways in which you could have performed this contract which didn't involve coming to London and arbitrating. All of those would have involved not suing at all. The one thing that we know is that suit has been brought, and suit has been brought in a place other than London. And now actually we simply seek to enforce the obligation to have the disputes relating to the bringing of those suits enforced in London, which is where the obligation to enforce those claims falls to be performed.
Right, well, I've been trying hard, Mr. Hancock, not to interrupt you in the middle of a sentence.
Too big a pardon.
But it is now 1:05. You said you'd finished by now, but you haven't. How long do you expect to be?
I will be as rapid as I can be. I am at page 30 of 34, so I will be, I think, no more than 35 minutes or so.
Well, you in fairness to Miss Stillnot, you must finish by 2:30. 2 o'clock.